SJC-12605, Commonwealth v. Christopher Rivera.
Mr. Cohn, good morning.
Good morning. May it please the court, my name is Jinho King, and I represent Christopher Rivera. We asked the court to reverse the judgment of conviction because the evidence was insufficient to prove that Mr. Rivera committed an act that constitutes aid or assistance as an accessory after the fact. And put slightly differently, we asked the court not to expand the scope of accessory liability to include essentially the statement of a falsehood that does not tend to exculpate the principal. So this, our position is consistent with the language of the statute, it's consistent with the common law, and it's consistent with essentially the entire history of the case law on the crime of accessory after the fact.
So your position is if your client's only interest is to protect himself, he's not trying to help Hector Soto, he just wants to protect himself. But as a result of what he says and doesn't say, produces and doesn't produce, the police are misled as to this murder, that would not constitute accessory after the fact.
That's correct, and it's even before we get to that intent question, it is what is the act that he does? And if the act that he does, in this case, which is stating that he wasn't present.
Well, he said more than that. In the light most favorable to the Commonwealth, he knows more than this person's name is Joel. In the light most favorable to the Commonwealth, he knows who committed the murder and is not letting them know in the manner in which he's referring to somebody by the name of Joel.
Right, and the question is, does that false statement, does him falsely saying that he doesn't know his full name, the question of whether his false statement that he wasn't present at the scene, does that constitute aid or assistance?
He doesn't have to say anything. He doesn't have to say anything. He can just say, I don't know, or no, but he's decided to talk. When he decides to talk and he decides to not let them know who the murderer is, even though he knows, and he doesn't give them the name, the question is, going back to my original question, is that accessory after the fact if his motivation, the content of his consciousness is, I want to protect myself?
So certainly, if his intent is to protect himself, then there should not be a crime, right? And perhaps that, hopefully that answers your question more directly.
Isn't the problem here, it's a mixed motive case? That one can try to protect him herself, but also try to protect the principal. And I think that's what we have here. And that's what makes this case so tricky.
Right, this case is definitely tricky on the intent question, and there's two cases, both from the appeals court, that I think help illustrate why I think it's important to focus on the act as well as the intent, not just the intent.
But in this case, a very fine trial judge instructed the jury that you have to find specific intent to protect the perpetrator. And the defense attorney, his entire closing argument was, no, he was just trying to help himself. So this issue was brought before the jury. They were properly instructed that the intent specifically has to be to protect the perpetrator, the principal, and the jury found him guilty. So how do you get around the jury instruction in the context of this case with your mixed motive issue?
I think it's simply because the evidence was insufficient. The evidence was insufficient on not just the act, but also on the intent. And as I was saying, there's two appeals court cases that kind of thread the needle in terms of the mixed motive question and what kind of act is required for there to actually be assistance or aid.
Yeah, let me make sure I understand. So I gather your position is that if he had said that Soto or Joel was with me the entire time, we went straight home and we were not there, then you would be left only with your argument as to who he was trying to protect, himself or Joelle.
Absolutely.
But you're saying because he did not give, because nothing here provides an alibi for Joelle or for Soto, because he said, I was alone, that regardless of the issue of, even if he intended to help Soto by saying so, you're saying the evidence is insufficient because it does not constitute assistance in the absence of it being a false alibi.
That's correct. Essentially that there has to be some tendency to exculpate the principal in whatever act that you're trying to do, or to assist the principal as the common law has established, essentially the harbor.
And if you are right as to that, would that mean that this is, our interpretation of the accessory after the fact would be consistent with our interpretation of Section 13D in Paquette and Morse, the distinction between I don't know what happened versus he went that way?
Yes, I think that's absolutely true. The distinction is critical in the sense that whether you are assisting the principal, whether you are giving the principal some place to hide, whether you're giving the principal, obscuring the evidence against the principal in a way that destroys the evidence.
So you need more than just willfully mislead. You need, as the chief is referencing, the Paquette specific intent to impede.
So yes, it's
that what you're saying?
consistent. I'm saying that it's consistent, but there's also the question of what the act itself is, right? With whatever the intent is not enough under accessory after the fact. There must also be an act that is consistent with what the statute says. That's the harboring, maintaining, and other aid or assistance.
So if you lose here, is the practical effect that the Commonwealth can proceed with accessory after the fact where a person misleads in a manner that would not constitute the crime of misleading under 13F?
This, if we lose here today, this gives the Commonwealth more power to essentially go after lies, essentially no matter how immaterial they are, so long as there's some evidence of intent. And I think that gives the Commonwealth a power that it hasn't had before. To the extent that there are other statutes, like the statute that Your Honor mentioned, the witness intimidation statute.
13B, by the way, not 13F. I made a mistake.
Those kinds of statutes, the legislature has specifically stated that misleading a police officer, for example, with the intent to obstruct some kind of proceeding, that is a crime.
You're saying this would be like federal lying to a police officer?
It would be similar, although for that, this is 18 U.S.C. Section 1001, something like that, there is materiality requirements. It can't just be any lie. It has to make a difference.
Right, I assume even under your, I guess, parade of horribles, there'd have to be some materiality, right?
I think that the language of the statute doesn't specifically state materiality. The case law doesn't necessarily state materiality, but what it does demonstrate instead is that there has to be something that aids or assists. That's
But
more
a
than
lie
mere.
can be the materiality. I mean,
Certainly, a lie can be material.
and is this case stronger than Commonwealth versus Pizarro?
This case,
For the Commonwealth or for the defense?
it's certainly stronger for the defense.
Why?
For several reasons. Key is in Pizarro, the act of accessory after the fact was not the lie. The lie was just evidence of his intent, right? The consciousness of guilt, as the court said. Pizarro was actually about the defendant assisting the principal in hiding the proceeds of the theft, right? The cloth, I believe it was. That's what Pizarro was about, and all the cases that cite Pizarro on the question of the lie is actually citing it for the proposition that it's consciousness of guilt evidence, right? But there had to be an act as well. It wasn't just the intent, it had to also be the act. The act there was helping to hide the evidence. And there's plenty of case law about hiding evidence being something that falls within assisting a principal. That's not what happened here, right? This was lies that essentially took Mr. Rivera out of the picture, right? In a way, it made it impossible for him to exculpate the principal because he couldn't give the principal any alibi. He couldn't obscure any of the evidence because he essentially wasn't there, according to his story, right? He went home alone, and that's it. And for that reason, I think it's important to remember that there has to be an act. If there is no act, there cannot be the crime of accessory after the fact.
Now, appears to be common law crime day. I gather that accessory after the fact is the statutory embodiment of what was a common law crime.
That's my belief, yes.
Is there any tradition in the common law that would interpret accessory after the fact to include something which does not exculpate the defendant?
Well, I can say that Blackstone gave some examples of what accessory after the fact includes, and it's things like getting a horse for the principal so that they could evade the officials, or bring them into the home, giving them succor. Things like
What was
that.
the common law misprison of a felony? Do you remember that?
Yes, and that's discussed in the amicus brief.
Okay.
And so that crime is not something that I think really has become anything in the Commonwealth, at least. And there's not that I know of that there's any case that says that exists. The idea that you have to inform the officials as soon as you know of some kind of crime being committed, that's contrary to ideas that our constitutions have established. And I think that gets to another potential act that the court can consider in talking about Mr. Rivera's situation, which is what to do about his refusal to provide additional information, such as the phone numbers on his cell phone. And I think that we're consistent with the previous argument. We can't allow a crime to be committed where it's simply exercising a constitutional right to refuse. Again, I distinguish that from lying, right? Certainly, if there's a lie that exculpates a principal, that I think falls within accessory after the fact. That's not this case. Again, this case is a lie that does not tend to exculpate the principal, and on top of that, an exercise of the constitutional right to refuse.
How do you distinguish Wood?
Wood. Wood is the
abortion
one of the
case.
abortion cases, right? So in Wood, there were a couple components to the act, right? One was the defendant told the victim and her family not to go to the police,
But
essentially.
didn't the
Keep them out of it.
Wasn't a defendant questioned by the police, and he says, I don't know anything about anything, basically. I'm just a handyman.
Even more than that, he said, I've never seen them at this house. And that's critical, because if they had never been at the house, then that abortion could not have occurred in that house. So in making that statement, a false statement, he exculpated the principal who performed the abortion. And so in all of these cases, consistently in the Commonwealth, there has always been some assistance to the principal that exculpates the principal, right? If believed, it would tend to exculpate the principal, and that is simply absent here. And so if we need to, and we can talk about this mixed intent situation, and there's cases where mixed intent goes in favor of the Commonwealth, and there's cases where the mixed intent goes in favor of the defendant, but even stronger than that.
And what have the other, I forget if it was your brief or the amicus brief, and what have the other states done in this area to help clarify these mixed intent cases?
Right, so this is, again, in the amicus brief. The cases outside the Commonwealth are consistent in that a mere lie that does not tend to exculpate the principal is not enough. It has to be more than just that to be the act.
So would you say that looking at Paquette and going back to the Chief's question, that if you took the elements of misleading a police officer, and you added a material act that tends to exculpate the principal, that would be sufficient?
Yes, I do believe that that would be sufficient, but there has to be that second component which you just mentioned, the act that tends to exculpate the principal, or wipes the prints off the knife, something that destroys the evidence.
And in
which
this particular case, you would say that in trying to determine what's here, we can't consider the refusal to show the contact in the phone because we can't criminalize an unwillingness to consent to a search.
That's right. And because otherwise it would vitiate the very protections that the Constitution guarantees. I see that my time is up.
Can I ask you a question?
Absolutely.
Were the police misled in this case?
The actual truth is that they were not, because they knew who Joel was. They already knew the layout of everything that occurred. So they were not actually misled by what his statements were.
So is that the difference between I don't know and then he went that way?
That is an interesting distinction. I think the way that we can think about it in this case is that we have case law talking about how the actual effect of the statement or the act is immaterial to determining whether someone's an accessory after the fact. But if we look at it as to the question of intent, certainly the police were making very clear that they knew what was going on. They said it repeatedly to Mr. Rivera during the interview. In that sense, Mr. Rivera, his statements, it could only exculpate himself, or could only try to exculpate himself. It couldn't really touch anything else. Thank you.
Ms. Campbell?
Good morning, and may it please the court. Kaylin Campbell on behalf of the Commonwealth. We ask you today to affirm the defendant's conviction as there was sufficient evidence that the defendant was an accessory after the fact based on false statements he gave to the police. And I'll start with a question that the chief asked about the common law. And my brother mentioned Blackstone, and I think Blackstone is a great place to start because Blackstone actually says, when it's talking about this specific crime, generally any assistance, whether given to a felon to hinder his being apprehended, tried, or suffering punishment, makes the assister an accessory. And our case law has interpreted that to say that it's the obstruction of justice component that's the gravamen of this crime. And in that way, a lie, and a lie such as the defendant gave here, is sufficient to meet the requirements of the statute. And I point, it was mentioned over and over about what the defendant did, but I think it was underplaying what his role in this crime was because he was a participant in this crime and he was a recipient witness to this crime. So he lies about what he did that evening, he lies about who he's with, he lies about his actual observations of the crime. My brother said that he believes that it would be sufficient evidence in this case if an individual undertakes actions which would obscure evidence in a way that destroys the case. And when you have a percipient witness who does not choose to invoke his rights, we talked about refusal a lot, but this isn't an individual who chose to refuse to speak to police. This is an individual who elected to speak to the police and then lie to him. What he did was he obscured the evidence in a way that was detrimental and destroyed the case because he was a percipient witness to the crime and he refused to recount what he saw.
He would also incriminate himself, though, if he did so.
Sure, but if he wants to invoke a fifth, or if he wants to if he wants to elect not to speak to the police, he can choose to do that. That's not what he chose to do. And where an individual chooses to speak to police and chooses to lie to the police, then the Commonwealth is absolutely justified in charging that individual with a crime.
Does it matter if the police already had some of that information already and knew the real situation?
No. I don't believe it does for purposes of this crime. I think that's where it gets an interesting interplay between 268 Section 13B and here, because there is that requirement that the misinformation be given in a way that actually misleads in a material way the police investigation. I think that distinction can be drawn. But that's not to say that what the defendant's behavior here shouldn't be a crime and shouldn't be a crime for which he can be convicted of.
But the concern is we have worked hard to cabin the scope of the meaning of misleading of a police officer in 13B.
Correct.
You couldn't have charged him under 13B because of the way in which we have cabined the scope of 13B, correct?
So looking at Paquette, the language specifically, and this is in page 802, depends on whether it reasonably could lead investigators to pursue a course of investigation materially different from the course they otherwise would have pursued. I'm not sure what the interplay between that reasonably could
Okay, but
and how that relates to when you have a percipient witness giving them information that he wasn't materially there. They could, in effect, had they believed what he said, investigated what he said as opposed to investigated the way that they chose to.
essentially, you're asking us to interpret accessory after the fact to be the equivalent of the federal false statement to a federal officer under 1001. I mean, isn't that effectively the result of what we'd be doing here?
I'm not sure, but I would also say that what I'm asking you to do is what the case law has repeatedly held that this statute.
But you can't find any case in which we've adopted we've used the accessory after the fact to find somebody guilty where there was not at least a false alibi offered.
And I disagree with that.
Okay,
I
where-
absolutely disagree with that.
Show me the case in which,
Sure.
show me why your brother is wrong on that.
Sure, so in Doherty, the information was that he met with a group of people and they decided to come up with this statement, but all he said to the police was that he had been in a fight, he had run from the porch, and he found Davis's body when he returned. I'm not sure how that exculpates or gives a false alibi to the two individuals who were not part of that group, who he doesn't give any information about. So that's Doherty, that's one. The second, in Wood, I disagree as to what this court in Wood held were the false statements. And this can be found, I'm quoting from the case, it says, the false statements which would be enough to constitute accessory after. Wood said that he did not know these were belongings that were found in a coat in that room that he stayed in the house. Wood then said that he did not know to whom the wallet or the letters belonged or how they came to be in his pockets. The sealed letter was opened by an officer and read to Wood, and he said that he knew nothing about the type of work and absolutely nothing about medicine and nothing about what goes on. All I do is chores around this house. So again, that's a disavowal of knowledge that he has, a disavowal of the information that he could give.
But he also, if your brother is right, and I think from my memory of the briefs, he is right, that he also said they were never in the house, which would be a false alibi.
It would be a false alibi, but I think that just because that does exist doesn't mean that the specific falsehoods that the court relies upon and points out and says that various false statements of the defendant to the police officers might have been found to mislead them in the investigation for purposes of assisting Dawn. So there is a highlighting that these various false statements in and of themselves would have been sufficient to constitute the crime of accessory after the fact. And I would also point to Spizzaro.
Could you just tell me here, what is it he said that is enough?
Oh, sure. Well, it's that he lied about where he was that evening because he was with the defendant before
He
the
lied
murder took
about it
place.
to protect himself.
We could have mixed motive here. So he lied about where he was that evening. He lied about the fact that he drove himself. He lied about the fact that he didn't go to 7-Eleven, which when he was with the principal and engaged in the fight. He lied about the fact that he went home by himself, and I think this is critical because he goes home with the principal as they're fleeing the murder. And he also, gives misinformation about the principal's name. He says it's Joel, and he says that he does not know any other name for him, where the evidence was substantial at trial that the principal went by Hector or he went by Nemo. And he told the police that he had the principal's phone number, but he wouldn't give it to the police.
Is he obligated to give that number to the police?
He's not, but again, where you decide to speak to the police and you decide to not give them information.
Right to remain silent. You may stop at any time.
Sure. And he doesn't invoke his right to stop at that point. He doesn't say, I don't want to talk to you
But I
anymore.
prefer not to give you the number. He's entitled to do that without invoking a right that he effectively did invoke a right by saying, I don't wish to give you these telephone numbers.
He doesn't just say, I don't wish to give you this telephone number, though. He says, I don't want to get other people involved. I think that evinces the reason why he's giving the information he doesn't give the
If
telephone
that's
number.
all he did, would you say he committed a crime?
No, but that's not all he did.
Okay, but how does that add anything to it? I mean, best I can see is all he did was say, I drove home alone. I mean, yes, so he referred to him by his middle name as opposed to, but you knew who he was, not, I mean, the police knew who he was, so I don't get how that is misleading. They all knew that Joel was Soto.
Because what's required under this crime is not that the police are actually misled. What's required is that the individual undertake actions with the express purpose that the principal, he assists the principal avoid prosecution and punishment.
But you can assist the principal to avoid prosecution and punishment by not cooperating with the police, but it's not a crime to not cooperate with the police. It arguably is a crime in some circumstances to mislead the police. So it's the failure of cooperation, you're not telling me that the failure to cooperate with the police constitutes accessory after the fact.
Not at all. Not
Okay,
at all. But I'm saying
so where are we then? You're saying that
we are at the instance where we're criminalizing conduct where an individual, in this instance, and I think it's important in this case to point to the defendant and what exactly he did in this crime, because he's not just the principal's friend who decides to not speak with the police. He's a recipient participant in this murder.
you could have arguably charged him with joint venture murder.
We could have.
So when
But
he
that-
was,
but
when
that
he was
does-
faced with being questioned, he reasonably could have said, if I admit that I was there, what I did there would constitute joint venture murder, first degree or second degree.
Sure, but at the point in which he undertakes the calculus, where he gets Miranda warnings, where he decides to not invoke his rights, he decides to speak to the police and lie to him, that's the crime. And so the question is, when he makes those lies, under the common law and under the case law, I believe, it criminalizes a person who does that. And the question when looking at the specific lies he gave is whether he did so with the intent to just protect himself or whether he did so with the intent to also aid the principal.
Put aside the intent issue. Let's assume that the mixed motive would be sufficient for you to win. The real issue is whether or not the line is whether he must not only lie, but also lie in a way that provides a false alibi.
And I would say absolutely not. And I would say the case law doesn't even stand for that. As I pointed out before, as I pointed out in Doherty, as I
So
pointed
no
out in
act is
Wood.
necessary?
The act is lying. An act is necessary. The act is lying. I would also.
By itself is enough. It doesn't have to be one that would aid the principals.
It does have to.
Suppose he was eating an ice cream cone and he said, no, I never have ice cream. Is that lie?
That's a lie, but it wouldn't aid the principal.
Are you
in-
saying that the lie has to aid the principal?
That's what the statute says, yes.
Okay, so you agree with that.
Correct.
So how do these lies aid the principal?
His lies aided the principal because he doesn't give, they aid the principal because he's with the principal that evening.
Yes, and he's going to lie about that. I'm not with him. So what? How
Sure.
does that aid the principal, not him?
Because it is evidence that could be used against the principal in furtherance of the
So a lie
prosecution
has
of the
to
crime.
be
But
somehow-
it's not just that evidence, it's also, he gives the false name. Well, he gives the name of Joel, which nobody else calls this individual Joel. So it's making it, he's making it more difficult for the police to investigate who the person is. And I disagree that this is some sort of immaterial type of statement, because people don't go by their middle names and people aren't commonly known by their middle names. So if you were to ask my boss who works for you and he would say Marie, I don't know her last name, you wouldn't know that he was talking about me because I don't go by my middle name and you don't know my middle name. And it could be, depending on how you're investigating it, difficult to find out who that individual was. So I think that that is important for purposes of determining what this individual's actions were. But even more so than that, at the point that you decide to speak to the police, you say, I have this individual's phone number. They say, okay, can we have it? And you say, I'm not going to give it to you. I don't want to get other people involved. Then yes, I do think that that is also evidence too, which should be considered and is part of the sufficiency
That's evidence of
calculus.
his mixed motive, right? Because he clearly is concerned about protecting someone else. That's right. So that's the most relevant part of his last statement is that he is caught up in other people as well as himself.
Correct. And I think at the point that you elect to speak to the police, then you waive whatever rights of refusal that you would have if you elected not to speak with them.
And if you fail to speak to the police, then you're hindering the police?
I don't, that's not an argument that I'm making. I know that was an argument that was made today. I would not.
Help myself.
Yes, no, I would not make that argument, Your Honor, no. I'm happy to answer any other questions, but if not, the Commonwealth will rest on its brief.
All right, thank you.